In terms of the privacy for the public sector, the U.S. Constitution does protect individuals from wrongful invasion by the state or by anyone acting on its behalf, where the government is the employer. The Fourth Amendment is a protection against unreasonable search and seizures. And the Supreme Court has been very liberal in the way that they've interpreted search. For example, blood samples and bodily invasions, urinalysis, and things without a just cause for doing that. So you can't just randomly do it. You cannot do it without a reasonable expectation of there being a problem, and therefore that's the only solution to addressing the problem. In terms of employer-owned property, they can search computers, desks, and lockers, assuming that there's some advance notice and then follow through on things. Now, what if you are using your cloud storage, for example, using Dropbox or things like that with your personal information on it, um, and um, and it's on your company computer? It depends on whether or not the the access to the computer and to the cloud storage is made public on that computer. Like you can link to Dropbox, but not um, sync all of the folders that you have in Dropbox with your work computer. So it is important that you keep only your work related data syncing so that there's no issues of privacy being violated, and or that you don't get called out for things that are in your private Dropbox or your private cloud storage that people really would not have access to. So the important thing is to make sure it's under a password protection, and that the folders that are private to you are not synced to your work computer. We can search employee property like backpacks, briefcases, purses, and wallets only if there's forewarning and consent to be made prior to the search. People should be made aware of what is the procedure, why it is being laid out that way, and making sure that people know um, why the property is being investigated. An employee may have a claim for false imprisonment when they're being detained during a search, so they have to have the freedom to leave if they choose to and not feel like they have to be detained. That's considered false imprisonment, and that case law has supported this. The Fifth and the 14th Amendments have clear tests that employers have to follow in order to um, basically impose on someone's privacy. There is a strict scrutiny of fundamental rights requiring compelling state interest to justify violating somebody's privacy. States can impose any restrictions that can be shown to be rationally related to a valid state interest. Is it a fundamental right? Well, it's implicit in the concept of liberty. And it is part of our nation's history that we have a fundamental right to privacy. So even though there is no general right of an individual to be left alone in its entirety, right? But we do have some degree of uh, fundamental right to um, privacy in the workplace unless there is a compelling evidence or a compelling reason why someone may be engaging in behaviors that could be detrimental to the state and to the organization within which they work. The Privacy Act of 1974 regulates the release of personal information about federal employees to federal agencies. There's two basic principles to it. You want to restrict disclosure of personally identifiable records maintained by the agencies, so you can provide information, but it cannot be personally identifiable. And we want to grant individuals increased right of access to agency records maintained on themselves. So that what that also means is if someone has a record of you, like an FBI folder, right? you're a person of interest by the FBI, and they may maintain a folder on you. And if you're working for the federal government, you have the right to access that information to some extent. The Privacy Act also grants individuals the right to seek amendment of agency records maintained on them if they are inaccurate. So let's say it has inaccurate information about your birth date, or it has inaccurate information about disciplinary issues. You can petition and seek to have those records amended properly. So we should be able to have access to that information. It's, basically, freedom of information about ourselves. What the goal is of that Privacy Act was to establish a code of what we call fair information practices, so that we are not keeping inaccurate records on people, which could be detrimental to their careers and to their liberties to work as they choose to and to live as they choose to. So as long as we have that information and we can accurately make those changes, that can work. A right to privacy is not absolute, right? If there is some belief that you are working against the interests of the employer in some way, then of course that information can be made public. So the extent of protection varies with the extent of the intrusion. Interests of the employee are balanced against the interests of the employer. Again, it's always this push-pull, like what issues does it affect the employee versus, the impact on the employer. Um, there's always that tension. The individual's interest in disclosing the information sought has to be considered. The public interest in that disclosure has to be considered. The degree of invasion of personal privacy has to be considered, and whether or not there are alternative means to get the information. So if there's an alternative way to get info, then obviously we would not be invading somebody's privacy in that manner. So all of these are important factors to consider when you are going after information about a particular employee, and all these things have to be balanced. So it is always important before you're diving into private information is making sure you get legal support on this, and making sure that it can fit within case law about what you can and cannot do on these particular on your particular investigation. There has been a study commissioned to look at whether or not we could extend the Privacy Act to the private sector. And nothing has been agreed to yet, obviously, and depending on who is in the White House and who is in Congress, this is always a challenge in terms of whether or not this actually would be enacted. But here's what the Privacy Protection Commission said. The use of polygraph tests in employee-related issues can still be prohibited and should still be prohibited. And we talked about this in other, data early on about the use of polygraph in staffing needs. That the pretext interviews should be prohibited. Again, using an interview as a pretext for discriminating and violating somebody's privacy. The use of arrest or criminal records in employment decisions should be restricted, and employers can be required to use reasonable care in selection of their investigating agencies, and the Federal Fair Credit Reporting Act provisions would be strengthened by this. So again, none of this is legit at this point. It's something that is recommendations that were made by the commission. Congress has yet to act on it, and of course it's hard to know, what will happen depending on the makeup of Congress at the present moment. In terms of wiretapping, Title III of the Federal Wiretap Act says that it governs the interception of oral, wire, and electronic communications related to criminal offenses. It's the basis for most statutes in states. There are some states that have a one-party consent. There are states that have a two-party consent, and you should know what state you're in and what those requirements are. Know that digital assistants such as Alexa and Siri may actually be eavesdropping devices. We already know that those tools hear what is going on in your home. Like, you can talk about something in front of Alexa, it hears it, and then suddenly you're going to have advertisements in your email and on your web searching that are related to some of the things that you may have been talking about in the privacy of your home. So it's one of the reasons why I don't have Alexa at home, and I rarely, if ever, use Siri. because I know that they are listening to my private conversations and they're providing targeted marketing to me based on those private conversations. And so be aware that when we're using these digital assistants, as fun as they might sound, you also have to take care in what you're saying, in front of them and around them. The Electronic Communications Privacy Act, the ECPA, covers all forms of digital communication and includes transmissions of texts and digitalized images, as well as voice communication on the phone. It prohibits unauthorized eavesdropping by all persons and businesses, not just the government. So we are protected under that. And interception applies only to messages in transit and not to messages that have actually reached company computers. And so, again, the in transit is when it's between point A and point B, but you cannot then access it once it's on someone's computer. You would have to access it through a different method, not from the source and not from the where it reaches, but sort of during that transit between the 2 points, which makes it, of course, more complex when you're dealing with internet and things like that. When it comes to private sector employee privacy, there are clear limits with respect to people's privacy rights in private workplaces. There's no constitutional protection, and government actions are not, and particularly when government actions are not involved. So there are significantly fewer protections against intrusion. Because of the at-will provisions that we have in terms of private workplaces. So there is clearly a difference between public and private sector privacy protections and compliance-related costs for private employers. Sorry. The legal framework for employee rights in the private sector is largely around employment at will, that employers are free to fire any employee and employees are free to leave their position at any time for any reason or for no reason. Other than obviously breaking contracts, breaking collective bargaining agreements, if state law it has exemptions to employment at will, which we need to be aware of on a state-by-state basis, and any federal or state protected things like whistleblowing and anti-discrimination like Title VII and ADA and things like that.